Hello, Southern California tenants. What actually happens after an unlawful detainer lawsuit is filed against you as a tenant? Let me break this down step by step, because understanding this process could save your housing situation. First, let's be clear about what we're dealing with. An unlawful detainer is the legal term for an eviction lawsuit. Once your landlord files this lawsuit, you're officially in the court system, and time becomes critical. If you don't respond to the lawsuit, and this is where many tenants make a fatal mistake, the court will likely rule against you by default. You typically have only 5 days to respond in California. Miss this deadline, and you've essentially handed your landlord an automatic win. But let's say you do respond and fight the case. There are several potential outcomes. If you win, you get to stay in your home and the case gets dismissed. However, if the landlord wins, the court issues what's called a judgment for possession. This isn't just permission to evict you. They can also award back rent, damages, and legal fees against you. Here's where things move fast. Once the landlord gets that judgment, they obtain a writ of possession from the court. This is basically the sheriff's marching orders to remove you from the property. Within days, the sheriff will post a notice to vacate on your door, giving you typically 5 days to leave voluntarily. If you don't leave during this grace period, the sheriff returns for what's called the physical eviction. They will remove you and your belongings, the landlord regains possession, and the locks get changed. You're officially homeless at this point. But the nightmare doesn't end there. Any belongings you leave behind must be handled according to state law. Landlords usually have to store your items for 15 to 30 days and notify you to reclaim them, or they can sell or dispose of everything you own. The financial consequences can destroy your future. If the judgment includes monetary damages, your landlord can pursue collection through wage garnishment or bank levies. This eviction will appear on your credit report, making it nearly impossible to rent anywhere decent for years. Now, you might think about appealing, but here's the harsh reality. Appeals rarely succeed without strong evidence of legal errors, and you'll likely need to post a bond to delay the eviction. The eviction record itself becomes a scarlet letter. Future landlords will see it and reject your applications immediately. Some states allow you to seal these records under specific conditions, but that's often after paying everything you owe. Remember, procedures vary by state, but in California, this process is governed by Code of Civil Procedure Section 174. Other states may have different timelines or protections.